Good evening and welcome on back to From Day 1, Part 2. The frauditors, auditors, subsets, and the like are waiting in the wings. But, good news! The cake! It's back! At least a hole in the missing parts of the cake, that is. As always, we grab to the mailbag first. And, ooh, emeralds. I like emeralds. Alright, so we start tonight in court with a drunk driving defendant that probably couldn't care less about his plea deal.
Ypsilanti Township versus Edward Ojinaka, case number 21T00205. Good morning, Mr. Ojinaka.
Good morning.
All right, we're here for final settlement conference today.
Wait a minute. The defendant is lying in bed. You can't even sit up? No?
Your Honor, there's an offer here of OWVI, which I had spoken with Mr. Ojinaka. I told him if he needed to speak with me again about it, I would request a breakout room.
So it's a felony plea down to misdemeanor, and this asshole still can't get out of his own bed.
I'm assuming, but not sure, that the people are able to proceed.
Yes.
Mr. Ojinaka, did you need to talk with me again about that offer that we discussed?
Yeah, I'll take the offer.
Okay. The offer, Your Honor, maybe Mr. Barnett, if you could, well, actually, Mr. Barnett, could you confirm that my notes show that there's an offer of visibly impaired?
That is correct. We would add a count 2 of visibly impaired. That's MCL 257.6253-A. That's 93 days, $300.
Thank you.
And in return, we would dismiss the original charge.
All right, Mr. Ojinaka, as your attorney and the prosecutor have placed on the record, the offer is that if you were pleased with operating while visibly impaired, a misdemeanor carrying a maximum of 93 days and or up to $300 in fines plus clerk's parts, they would dismiss the more serious offense. Is that what you want to do, sir?
Yes.
All right. Could you please raise your right hand to be sworn?
It might require you to get out of bed. No, he's staying in bed.
Sir, you need to remove your hat, also. Okay? Thank you. All right. Now raise your right hand. You swear affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you.
I can't believe this, Your Honor. He's still in bed, and you're letting him continue.
Yes. There's a message that you're going to be getting up today. Please let me know if you have any questions about it.
Let's speed it up so we can get through the device right. Blah, 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 blah. You don't know. Holding the fast forward button. We'll be back to normal here in just a second.
You have the right to see, hear, and question all witnesses that are called against you in a trial. You have the right to witness for yourself or to remain silent. If you chose to remain silent, the prosecutor cannot comment on that. You also have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand all those rights, sir?
Yes.
You understand that you'll be giving
we're
up
back.
all those rights by entering into this plea today?
Yes.
Do you understand that there will be no automatic right to appeal this decision? So the decision that you're making today is likely to stick with you, sir.
Okay.
And so you understand that piece. Right?
That does require a yes, sir.
Yeah.
Mr. Ojinaka, you have to respond either yes or no. Or
I said yeah.
The yeah is not really an answer.
Yes.
Thank
There
you.
you go.
Sir, do you also understand that if you're on probation or parole, this could be considered a violation of that?
Okay. Yes.
On September the 13th, 2021, you were before the magistrate. You did sign an advice of rights at that time. Is that correct, sir?
Yes.
Did you read that document?
No.
Kind of, sort of.
See? No.
Are you a United States citizen, sir?
Yes.
To the charge of operating while visibly impaired, how do you plead, sir?
You said what?
To the charge of operating while visibly impaired, how do you plead?
I don't know. What am I supposed to say? Guilty?
You're supposed to say whatever you're choosing to do today, sir.
I don't know how this court stuff go.
Mr. Bannons.
Bannons, your
Your
client is
Honor,
an idiot.
we're here for final settlement conference. I do believe Mr. Ojinaka wants to take the plea offer, but I don't think he's able to at the moment. So my suggestion would be maybe we could have a pre-trial and we could do it there, and then I'll discuss all of this again with Mr. Ojinaka. I want to make sure he really understands what he's doing.
Mr. Barnett.
Yeah, I don't object to that. That's fine.
Thank you.
I'm going to schedule this for April. No, I'm going to schedule this for March 10th. No? Oh, we need Wednesday. What date is that?
Is that gonna be my last court date?
It could have
No, you're gonna
been
come back
this
for
if you
what's
wouldn't have
called
been stupid.
sentencing,
So how many more court dates I have to come back to?
As many as I tell you to get your ass here for.
Mr. Ojinaka, I'm going to be calling you tomorrow, and we'll walk through all this again.
Because you're an idiot.
Yeah. All right, I'm going to put this on for next week. Sir, is there a problem?
Yes, he's an idiot, Your Honor.
Sir, first of all, are you laying down?
He's been laying down the whole time, Your Honor.
You said what?
Are you laying down?
I'm at home.
No, you're in court, whether you're at home or not. Are you laying down?
Yes, Your Honor.
And if you can't behave properly in a virtual courtroom, then I can have you come into the courthouse. Do we need to do that?
Yes, Your Honor.
Oh.
March 2nd, 2022 at 9 a.m. for pretrial.
In person. In person. Make this asshole come in
All right,
person.
we'll see you next Wednesday, and you'll have a chance to talk to your attorney in the interim time period and figure out whether you want to handle this as a plea or if you want to actually have a trial. Bond in this particular case is continued.
Boo, he shouldn't have bond.
Thank you.
Thank you.
Alright, let me find us another court case. Sounds like there's going to be another secret spot, but it's not in the same spot as it was previously. Makes us required to go looking. Alright, let's go with this one in court.
You too.
Thank you.
Here we go.
Mr. Bradley, your lawyer doesn't want to be your lawyer anymore.
Is he here somewhere?
Yes, he is. It's right there. He's waving at you.
Oh, okay, I see it.
Yes, Your Honor.
Yes,
I
sir.
don't mind being his lawyer. It's just that I was retained several months ago, and the person who retained me is no longer in the picture. His family has been trying to come up with the money, has been unable to come up with zero money since then, and it's gotten to the point where I need to withdraw or get appointed myself or something.
What are you going to do about it, Mr. Bradley?
I don't have any money to keep him, but I would like to keep him if that is at all possible.
That's money makes the world go around. I don't know how you want to keep him but not pay him. So what are you going to do about it? Who are you going to hire?
Ghostbusters?
I don't have any money to hire anyone, so I won't hire anyone.
So you're going to be your own lawyer with a 7-count indictment.
No, sir. I mean,
Yes, sir. Yes, sir. I don't know what other options you think you have. I'm not getting you a lawyer just because the situation is the lawyer you hired isn't getting paid. So you've got very little options. Pay the man what he's due, hire somebody else, or learn to be a lawyer.
I like that one. I learned to be a lawyer.
Well, I need to know, and your lawyer needs to know which of those options you're going to do.
I don't have any money to hire anyone, so I'm kind of screwed.
Yes, sir? Yeah, you are. Okay, well, you know what 7 times 10 is?
70,
6 times 10.
60,
60.
60.
And then there's a 20-year allegation, so you're looking at 80 years
80.
in prison. And do you really think you know more than any of the prosecutors who are going to be taking this case on?
No, sir.
I can tell you your lawyer does. I'm setting this matter for a jury trial so that you know how much time you need to hire somebody else that doesn't have the experience Mr. Roberts has, or to give you time in the law library. But make no mistake, this case is going when I said it, and if you're the only lawyer around, I'm going to hold you to the same standard that we hold lawyers like Mr. Roberts.
Yes, sir.
Guys, we're done with him. The next one I have is George Briseño. Mr. Roberts, give me a chance. Let me see if anything happens. If not, I may need a motion from you saying that he's indigent so that I can appoint you.
Okay, Your Honor. I'll get with him immediately.
Well,
Okay,
give him
thank
a couple of weeks to see if he can find some family that has money. And so in a couple of weeks, if you can't seem to get anything, come back to me and with a motion.
Thank you.
Thank you. Thank you, Mr. Roberts, for being here.
See, the judge is still willing, but it's like just because you don't immediately go and get a free pass. Now it's time for one of the most interesting defense attorneys. I've seen, and that's going to be Derek Wyatt down in El Paso, Texas.
Morning, Your Honor.
Mr. Scott Ferguson, how are you doing, sir?
I'm upright and taking nourishment, Your Honor.
Didn't we miss that, Rick?
Oh yeah, it's been a long time. I'm just waiting for him to throw out the loco Perico.
I'm waiting for Derek to show up first.
I'm right here, Scott.
Hi. How are you doing, El Loco Perico?
I'm pretty good. I'm glad you're still upright, my friend.
Indeed.
Isn't it? Absolutely. It warms my heart to hear that.
He's like an Old Testament miracle.
Oh.
That's absolutely right. He's one
I won't disagree with that.
You are one of God's miracles, Mr. Ferguson, that we are truly grateful and happy to witness.
That is very kind of you, Your Honor. It is. I feel very blessed because I absolutely know it was truly a miracle, or I definitely wouldn't be here.
We know that. We all know that. We all know that. Who is EF? Rick, can you follow EF? God knows who he is.
Yes.
Remember E.F. Hutton? When E.F.
When people listen, or when he speaks, people listen, right?
Yeah.
My God, are we aging ourselves or what? Sure, these people have no clue who E.F. Hutton was.
No, absolutely not.
No.
Mr. Stockbroker Derek, did E.F. Hutton go to business?
Oh gosh, I don't know.
What happened to him?
I left that kind of life in Chicago and
Never looked back. Very good. I don't know if you were smart. You went from the stock exchange to the legal field.
yeah, not very.
Well, at least you didn't get defenestrated out of a high-rise building.
At least I didn't what?
Get defenestrated, thrown out of a window.
Oh, I've never heard such a term. What, how do you say it?
Defenestrated. Well, defenestrated is when you throw someone out a window.
You remember that scene, that famous scene in Beverly Hills Cop? Where all the bad guys take Axel Foley and they throw him out the window?
Yeah.
Then claimed Axel arrived there, started trouble, then jumped out a window.
Yeah, there you go.
He defenestrated out of a window. Say that again, Mr.
Defenestrated.
Defenestrated out of a window, Mr. Wyatt.
That's got to be the word of the day, defenestrated. All right, back to the judge.
Wyatt. At this time, court calls on number 2021-2133 and 2008-5618. Announcement to counsel, please.
Scott Ferguson, state your honor, state is ready.
Derek White on behalf of Mr. Gallegos, we're respectfully ready to proceed, Judge.
That is great. Thank you, Miss Alayandia. That's a great background. I just noticed you in the background, Miss Grassheim, and then... Oh my God, that's hilarious.
I keep telling everybody in the firm that we need to put that up as a new billboard.
You know,
because everybody who sees it loves it. But Justin Elaine is saying, that might not be able to that might not agree with the personal injury market that we're trying to court. I disagree, but I'm voted down. So what can you do?
I can't believe you let Justino be the main focus of that picture, Derek.
Hey, better than me.
Okay. Let me tell you, the one that looks stunning in the background is Miss Elena.
Everybody says that. She does.
She looks great. She looks stunning in that. Of course, you always do, and Mr. Underwood is a bit hilarious, but Miss Elena alone would be a good PI kind of face.
Yes.
Yeah, that ought to be the face of your firm. You know that.
Yeah, well, she's the managing partner now.
Oh, really?
Good for her. Good for her. Okay, you guys, this case, what did we offer the last time? Mr. Wyatt, this is a case that he was given like 10,000 chances. 20,000. So this is a revocation case. And what did we offer last?
We have, I've gone over this case so many times and I've sent emails and you're pretty set in your ways. The last hearing, from what I understand, is that it's 3 on the revo and dismiss the new Agasol.
Okay, that sounds fair.
That was our bottom line.
And dismiss the new case. That's pretty good. Ms. Salayandia, you agreed to that last time, right? I think we all said, okay, we can do 3, right?
Mm-hmm. That is correct.
And that's because he has so much time credit. He has 223 days or 220 some days in jail. Ms. Bustamante, how much time? I mean, God knows if they're going to give him 2 for 1 or 3 for 1 or 5 for 1.
It's actually around 2:45.
Okay, there it is.
Yes, I think that'll work out well for all parties.
Can we do the plea papers, please? That's music to my ears again.
Yes, Your Honor. I'll get the plea papers.
Amen. Okay.
They're just revocation papers.
Right.
Yeah.
We're going to dismiss the pending, but just make sure you do the waiver of arraignment, please. Okay, great. Plea papers on this one. Plea paper list. You made my day, Mr. Wyatt. Thank you so much. Did you have another one? Mr. Wyatt, did you have another one?
Yes, ma'am.
And Your Honor, I was expecting a big presentation by Mr. Wyatt. I thought we'd be here listening to 20 minutes of argument before we got this done.
We've got the next one you have is Cameron Stennis, 2021-26-23. Mr. Wyatt, announcement of counsel, please. And this is Mr. Duke's case.
Ray Duke, Your Honor, for the state. State's ready to proceed.
Derek White on behalf of Mr. Stenson, and we're respectfully ready to proceed this morning, Your Honor.
You know, I don't care how many emails we send. He's still in jail? I thought we had agreed.
Yeah, well, we agreed to, because of the new PR bond rules, we had to give him some sort of surety. So we gave him a $2,500 surety, and my staff has been trying to contact everybody they can possibly find who will pay $250 to bond this young man out. But we have not been successful.
Okay, but we did agree to the two. Okay, I thought it might have been on our part. We didn't do the appropriate paperwork. I
think everything is done, Judge, on the bond.
Good. Good. You did a great job, Mr. Duke, and we all did diligently trying to get him out. Okay. So
you
now,
did. I agree. 100%.
Okay. So let's try to settle this case then. Does everybody agree to a bond, Mr. Duke? Can we settle it?
I think I've given an offer to Mr. Wyatt. I don't know that he's willing to take it.
Well, tell me the
offer. Is the offer a dismissal?
No, I offered 10 deferred.
Yeah, but the problem is when you look at the evidence, you can't even begin to prove a case. I looked at it again yesterday. Looked at the video, looked for statements, don't see anything. In fact, the video is contrary to the police report.
You see, here's your show, Mr. Ferguson.
Exit the stage there, Mr. Wyatt. No, I understand what you're saying about the video, but if you watch the video, and it took me a little bit too, I promise you, but there is a gunshot in the video as well. And yes, I agree with you. The identity of the shooter is an issue. I agree with you.
So that's why Mr. Wyatt wants a dismissal, Mr. Duke.
It doesn't even appear from the video my guy was the shooter. When you put the whole thing in context, you know what I mean, and look at it, it doesn't even appear that he's the guy that's the shooter. And there's people accusing him, of course, but I don't even see statements from these people. Allegedly, there was a involved party one, and then there was a witness one. I've had myself and my assistant try to look for any statements by them. So, I mean, we basically have nothing. There's basically nothing even in Portal.
I'll take care of it today. All right? I'll take care of it today.
Okay.
Okay, so you want me to set it up again?
No, Judge. Set it for, if the court would set it for 2 weeks down the road, but I should have a dismissal to the court today.
Good.
And I'll get it taken care of.
Very good. We're going to reset this for a settlement conference in 2 weeks. Amen. Thank you.
Thank you.
Mr. Duke. I appreciate that. Thank you, Mr. Wyatt. I think you're done, Mr. Wyatt, right?
No, he still has some on page 3, Judge. He has 2 more.
On page 3? Okay, the next one is Mr. Manuel Rivera, 2018-3951, announcement of counsel, please.
Ferguson State, Your Honor, state is ready.
I'm sorry, Your Honor. Who did you call?
Manuel Rivera.
Manuel Rivera. Derek White on behalf of Mr. Manuel Rivera, and we're respectfully ready to proceed, Judge.
Manuel Rivera is here. Mr. Rivera, do you recognize Mr. Wyatt is your attorney?
Yes,
Yes? Where are you?
I'm right here.
There you Thank you, sir. Good morning, Mr. Wyatt. Do you recognize your client as the defendant in this case?
Do you recognize that
Yes,
shadow
ma'am.
as your
Let
defendant?
the record reflect that both have identified each other. What's the offer, Mr. Ferguson?
The offer on this is reduction to criminal trespass of a habitation, which is a misdemeanor,
Hmm?
and that's it.
You know, this, Judge, I know you remember this. This case right here was on the video that received international attention and viewed around the world. I don't know if you remember at the very end, I said, and Chaz, how about one for the people?
Is that this one?
Yes, here's this one. It's the complaining witness is deceased. The defendant has no priors. Baby mama was screwing around for visitation, so my client went to go get his kid. My guy is a truck driver, was arrested in Chicago. He got locked up. The company had to go tow the truck and trailer from Chicago back down here. The defendant lost his job. He was in jail for 28 days waiting to be extradited. And if you look at the evidence, baby mama and defendant's story don't really match. There's lots of inconsistent statements, and I'd hate to impeach a dead person. I mean, that would be really, really bad. This case is a 2018 case, and this received international attention.
International attention.
For people are clamoring for a dismissal in terms of justice on this.
It did.
How about time served, Derek? How about time served?
Scott is very, very generous, but this one deserves a dismissal.
Time served, Derek.
Scott, that's fair, but honestly, it deserves a dismissal. My guy has been through enough, and I'm even doubting the authenticity of the story. If you look at both parties who were a witness, they have completely different stories. They're not even a bit consistent.
I have a great idea.
Yes, Your Honor.
What about a bench trial? No, I thought it was a serious resolution. I didn't think it was funny. What about a bench? I don't know if you guys.
He's arguing for a dismissal. The prosecutor just wants time served so he can get it off the book.
I would say this is a great case for a bench trial. I don't even really want to waste the court's time with it. I'll give you a damn dismissal, Derek. You win.
That was justice. Thank you.
There you go, Mr. Wyatt, Mr. Ferguson. Thank you very much. You may be excused on that. Okay, the next one, Jason Rodriguez. Court calls number 2021-1445. Jason Rodriguez, announcement of counsel, please.
Scott Ferguson, State Your Honor. State is ready.
Derek White, on behalf of Mr. Rodriguez, respectfully, I proceed, Judge.
Michelle, just verify the agreement so that everybody's on the same page on this. Mr. Wyatt, you want to tell Mr. Ferguson?
We've got a the only thing I've got is a 5 deferred.
Is that right, Mr. Ferguson? You're okay?
I thought it was 3 deferred, but I'll take 5.
I will take the 3 deferred. I will take that 3 deferred.
3 deferred it is. There you
3
go.
deferred it is.
I didn't want to have to argue about the, photographs taken with
Yeah, this is a
garden implements or whatever, Derek.
Yeah.
We won't go there. We won't go there. We'll do the plea. Let's just get the plea.
That reminds me of an incident a long, long time ago.
Mr. I don't think it's appropriate to discuss on YouTube Live. You can discuss it privately with Mr. Ferguson. Thank you all.
Mr. Honor.
You may be excused. We'll come back to it. The next one is Eric Vargas. That is Mr. Wyatt, right?
Yes, ma'am.
At this time, court calls number 2021-2959. Announce on the council, please.
Scott Ferguson, State Your Honor. State is ready.
Derek White, on behalf of Mr. Vargas, respectfully ready to proceed, Judge.
This is a settlement conference. What's happening?
Present.
You want to waive the presence, Mr. Wyatt?
Yes, ma'am, if the court will allow.
Oh, wait. What's the offer, Mr.
The offer is, let's see.
And Judge,
3
he's in
years.
custody.
Thank you. Thank you. Thank you.
Hey, how long has he been in custody?
120, maybe 133, 34 days.
I'm thinking that's a 1244B. Time served.
I'm thinking 3 years, 5 months deferred adjudication, 1 month for every hit of acid that he possessed.
During a pandemic, that's barely a crime, Scott.
Well, he is old school. I'll give him that.
Yeah, exactly. How many people did? Plus, you know, it's not like fentanyl where you want to keep taking it. Take some acid, man. You're gonna have to rest for a few days before you can take it again.
Holy moly!
So it's not like meth or anything like that. I think seriously, a few months in jail during the pandemic for having some acid, that's pretty fair. I don't see him with any other history.
This is actually a second degree, Derek.
I know.
A lot of acid. I mean, it's certainly not personal use unless he's like truly a psychedelic commando or something.
I mean, 20 hits. Hey,
so your offer is 3.5 years to do?
No, deferred.
Deferred. 3.5 deferred. 3 years, 5 months deferred? You
Yes.
said? Okay, 3 years, 5 months deferred. Acid's pretty serious stuff, Mr. Wyatt.
Yeah, but you know what? When I think of the 171st, I think of important cases that need to be tried. And this is just really not an important case to have somebody sitting in jail over. Can we give him a PR bond?
Your Honor, I will agree to a PR bond.
You know, I think I would agree to a PR bond, too.
Thank you, Your Honor. Thank you, Scott.
Yeah, I think I'll agree to a PR bond. I'll agree to a PR bond. I think 3 years deferred is generous, though, Mr. Wyatt. Speak to your client.
Yes, ma'am.
20,000 PR bond, no bars, no drugs, no alcohol, no arrest, no offenses against the state of Texas. He cannot leave El Paso County unless and until he has my permission. He's going to report one time, 24 hours notice one time to his PR bond officer, 3 times a month. This is acid. 3 times a month, 24 hours notice for a UA.
Yes, I don't know, do we even have a UA that can pick up acid? It may require a special UA. I don't know.
Yeah, even the presumptive test picks up LSD.
Does it? I thought there was a special test for.
Well, at least there's a picture. There's a picture in evidence of the the field test kit, like a Ferguson field test kit.
We're not gonna go there, Derek.
I can contact our Miss Judge and find out.
Just like the term scot-free, it doesn't refer to me, neither does the Ferguson field test.
Very good. Okay, we're going to find that out, Mr. Wyatt, but I think we're done with the PR bond. We'll let him out. We'll set it up for another settlement conference in about another month. You work on Mr. Scott Ferguson, see what you can do.
Now, Scott, did you look at the acid?
Yeah, but I mean, you know as well as I do, it's homemade.
Yeah, but here's the thing. It was a picture. It's Donald Trump acid, and he's like, I don't know, is he throwing up into a garbage can? He's got like white hair, but it's obviously it's like Donald Trump throwing up into a garbage can. That's what's on the acid.
It's probably what he saw the last time he dropped a hit. Right? I mean, really. I mean, these are simple tabs. I know it's not microdots. It's not. You know, I know. I mean, he just little drops on cut up. You know.
What did you find out? Okay.
All the rest are PR bonds.
He should be out. Okay, Mr.
Yes.
Wyatt. Great. Thanks.
Fantastic. Thank you, guys.
3-week reset on the settlement conference. Thank you. You may be excused. Have a great day, Mr. Wyatt. He's been on for 4 years.
Thank you. That was interesting. Alright, what else do we have?
Morning, Your Honor.
No, we already did that. Let's go over to Mike.
this is Attorney Mike. I'm coming to you from Chicago as usual.
Yes, you are now. Shush.
Today I've got a good old fat.
Okay, there you go. Just because I don't like your dogs. Well, your dog plea, that is. All right, let's begin.
All right. DJ Howard, I'm assuming you're Daryl Howard. I'm going to ask you to unmute your device, turn your video on. Mr. Malaro, you as well. Hi, Mr. Howard.
I'm here, Mike. I'm here.
Okay, you can get your face away from being 0.1 centimeters from the screen.
All right, awesome. All right. This is in the matter of the people of the state of Michigan versus Daryl Lamont Howard Jr., file number 19-19661FH, ex Salvatore Malaro, appearing on behalf of Mr. Howard. I have Sarah Brenner appearing on behalf of the Attorney General.
Your Honor, I'd like to represent myself.
Well, don't interrupt me, so hold on a minute.
Mike, do you really got to give me a self-stead in this? All right, let's go.
I have Sarah Brenner appearing on behalf of the people. This is the date and time set for a pre-trial in this matter. This is actually a final pre-trial before trial. We are scheduled for trial on March 9th, next week at 10:30 a.m. So, Mr. Howard, I will now, what did you say?
I said I would like to represent myself. I'm here in corporate persona. UCC 1-308, reserve all my rights.
Okay.
Yeah, this fucker is a self-stead. Oh, Jesus Christ. Mike, we're going to have a talk after this.
So you wish to...
Just keep watching. Both Attorney Brenner and Malaro are fantastic. They both leaned in to make sure that they caught it all. And it is fantastic. Also, the judge is great. She's having none of it.
You no longer have an attorney represent you?
I'm a man in flesh. I'm representing the subject. I'm here for the subject matter ahead.
In other words, yes, he's an idiot,
I'm
Your Honor.
representing myself. I'm here under these guys.
So you wish
Representing my
to...
man living.
Say it again?
He's wanted to
Man
be an
living,
idiot, Your
flesh.
Honor.
Daryl Howard, on the record.
Well, you're not dead because you're talking to me, so, but I don't know what you're saying other than that. But so you no longer wish to have an attorney represent you?
That is right, Your Honor. He wishes to be stupid.
Okay. Do you wish to have an attorney as a standby counsel to answer questions if you have any?
No, Your Honor, I like to represent myself.
No, Your Honor, he's an idiot.
Mr. Howard no longer wishes to be
persona.
Well, Judge, I would suggest that Mr. Howard hear out Miss Brenner before he makes a final decision about having an attorney.
All right, so Mr. Howard, evidently something arose, and Miss Brenner has something she'd like to place on the record. So what I would suggest is that you hear what Miss Brenner says, and then perhaps you go into a breakout room with Mr. Malaro for him to explain the ramifications of it to you before I decide on your request to represent yourself. Okay?
Your Honor,
I'm stupid.
I reserve all my rights. UCC 1-308.
UCC does not apply to criminal matters, so.
I mean, it's obvious, but I've been waiting for a judge just to...
By the way, the UCC stands for Universal Commercial Code, which, Judge is definitely right, does not apply to criminal matters. Jesus criminy. Mike, you were going to talk about the judge laying the smack it down?
To hit him with that particular point. This judge has been fantastic so far. She maintains her calm, but she just smacks it down dispassionately and appropriately. It's fun to watch.
Okay, so Mr. Howard, Ms. Brenner, do you have a statement you'd like to place on the record?
Yes, Your Honor. Mr. Malaro and I have been discussing this matter over the last couple of weeks and discussing potential resolutions. After discussing this with Mr. Malaro, even though when the defendant was originally arrested, he owed just over $5,000 and arrearages have grown to over $8,000 at this point, I have agreed with Mr. Malaro to offer the following. If the defendant wishes to enter a guilty plea today, then I would be asking the court to set a sentencing date out 60 days. If the defendant makes his payments during that time period, which is only $150 a month that he's ordered to pay at this point, I would be requesting no upfront jail at the time of sentence. However, if he refuses that offer and we proceed to trial next week, when I convict him, I will be asking for immediate remand and I will be seeking incarceration because of the level of increase in his arrearages. I feel that this is a very lenient and generous offer that Mr. Malaro has convinced me to convey today.
Well, for the record, at trial, there's a conviction that I always remand to the custody of the
I love that part right there. She's saying she's obviously trying to get the defendant to take the situation seriously because she's making a nice offer, and she's saying, I'm going to ask for a remand. I'm going to ask for you to be put in jail, effectively. And the judge comes back with, for the record, I always do that, which is a thing of beauty. And then Attorney Malaro is sitting there just thinking, what a knucklehead. And also knowing, yep, they're not lying. I know both of them. I also forgot to do this in the beginning. I want to thank Craig Hastings for sending me this clip. It's really a fun one.
The Sheriff's Department. So if I ever have guilty convictions at trial, I take form of custody. So, Mr. Howard, so I'm going to go through that again with you. So the prosecutor and Mr. Malaro worked out a plea agreement that if you were to plead guilty, we would set sentencing out 60 days. And if in that 60-day period, you made the $150 per month payment towards your child support, they would agree that you would receive no jail up front at the time of sentencing. So at the time of sentencing, you would receive probation, but no upfront jail. So do you understand that's the plea agreement that has been reached?
Your Honor, I challenge the jurisdiction of this court.
And he's going to stick with the substantive bullshit.
Trial next week. So
I've sent in 3 affidavits, ma'am.
Affidavits for what?
For this particular matter, ma'am.
Come on, Judge, it's an affidavit of truth. No, this is too rich. This is too rich. He's so they've had multiple pre-trials. They're set for trial in a week, and he's raising jurisdiction right now. Of course, he's not doing any of it right. The judge takes it back to him in excruciating detail here. It's beautiful to see.
Received no notice of any motions, Your Honor.
No, I've not received anything, nor have you served the prosecutor. Mr. Howard, when I had to hire an attorney to represent, when I had a civil case, I hired an attorney because there's a great philosophy that only a fool represents himself. You have the right to represent yourself. Do you have a law degree?
No, Your Honor, but if somebody...
Do you have a college education? Do you have a college education? Okay.
I had given... No.
You have what?
He has no brain, Your Honor.
Okay. So, Mr. Howard, you feel free to represent yourself. Doesn't matter to me. But I'm just saying, you've been offered an opportunity for counsel who is intelligent and well-trained and well-experienced in the law. You may not like what he says, but Mr. Malaro always tells the truth. So, you do have the right to represent yourself. We received a letter. Okay, you sent a letter to the court. And you received a letter back stating that the court is in receipt of your letter mailed February 7th of 2022. Your letter is considered ex parte communication with Judge Angelo, which is prohibited. Judge Angelo, that's me, is prohibited from reading by Canon 3 of the Michigan Judicial Conduct Code. Additionally, you are represented by counsel, and any motions must be filed by your attorney. And your letter was returned to you. So the court cannot read letters from parties because that is ex parte communication. So that letter was returned to you.
That is just a classic illustration. Usually they don't take the time to discuss it in that level of detail because they don't have the time. But right here, this is the case she's got up. So this guy does put together whatever, some silly thing he got off the Softstit website. I'm guessing it's an affidavit of truth saying, he's conqueror of the world and there's no claim against him or some such thing. But just in the simplest terms, they don't understand the law. You can't just write a letter to the judge. It's an ex parte communication. Any communication you have with the judge, the opposing party, in this case the people, represented by Sarah Brenner, needs to have a copy of that communication. And if you want to discuss it further, you need to set it for hearing so that all of you are in the same place at the same time. So she just gets this crazy letter, which, by the way, is not going anywhere. What he wants is a motion to dismiss, although he doesn't have a basis. But if you want a motion to dismiss her, you need to file a motion, get a date set, have everybody there, and argue it. He has no concept of any of this stuff. But here we go.
If you file a motion, you must serve the prosecutor as well as the court. And so we don't have any motions. We just have a letter that you wrote. So you are scheduled for jury trial next week on March 9th at 10:30 in the morning. Are you prepared to go to trial?
I'll speak to Mr. Malaro after this, Your Honor.
I'm sorry? You want to speak to Mr. Malaro? Is that what you said, Mr. Malaro? You want to talk to Mr. Malaro? All right, I'm going to assign Mr. Malaro and Mr. Howard to the breakout room. Go ahead and join that breakout room.
You can do it.
Oh my God, he has a half a brain cell.
Right.
See if Mr. Malaro can talk some sense into him.
Israel Thompson's been here. Mr. Malaro, are you ready for me to bring Mr. Howard
I doubt it, but let's try.
back?
Yes, Your Honor.
That was pretty quick, Sam.
All right, Mr. Howard, you would ask for a breakout room with Mr. Malaro. Mr. Malaro, Mr. Howard, how do you wish to proceed today?
Your Honor, after explaining the offer to Mr. Howard, I believe he understands it. He's indicated to me he is not going to plead guilty to a felony of any kind, and he desires to represent himself in this matter.
All right. So, Mr.
No, he's an idiot, Mike. Really? You had to bring me an idiot.
Howard, you wish me to remove Mr. Malaro as counsel for you, and you wish him to be a standby counsel in case you have any questions?
No, Your Honor, thank you.
Okay, so do you understand how to prepare jury questions?
I'm going to assume that's a no.
I'm not sure I understand all the way, but I'm going to get it done. Your Honor, so what is
I'm talking now, Mr. Howard.
Shut up, Howard.
Understand how to prepare jury questions
That'd be a no, Your Honor.
and submit to the court.
I'm here purpose of son, and I'll do it. I'll do what I have to do because at least laws and land.
So are you going to prepare any requested jury questions?
No, Your Honor.
Am I going to prepare? Yes. Sorry. Excuse me.
Okay. Are you going to prepare any suggested voir dire questions?
Any what now?
Hey, he doesn't even know what that is, Your Honor.
Oh, I'm sorry. I didn't hear you. Yes. I mean,
when you get a chance, rewatch it and just look at the smile on Attorney Brenner's face when he said when he asked that question.
Okay, you know, those were already previous. Those were due yesterday. So I did not have voir dire questions. So Mr. Howard, I received the voir dire questions from the people, but not from you. So. Mr. Malaro, is it possible to forward to Mr. Howard the voir dire questions and propose
I'm confident Mr. Howard has no idea what she is talking about.
those jury instructions that you received from Ms. Brenner?
Yeah, I can send them out to him.
Okay.
I'll have our investigator deliver it to his house today.
Thank you. All right, so Mr. Howard, we will, Mr. Malaro will make sure that you receive the voir dire questions and proposed jury instructions that were filed by the people. The people also filed a motion in limine, and we've already held a hearing on that. Is that correct, Ms. Brenner?
Yes, Your Honor, and that was granted.
Yep, it was. So, Mr. Howard, you're set for trial on March 9th. Are you prepared to go to trial?
No, Your Honor, he's stupid.
If I can get an extension, that'd be great. But if I have to go March 9th, then that'll be the time I let it go.
All right, because you are self-represented now, I will grant an extension. It's only set for 1 day. So, Ms. Adams, could you bring the red book, please?
Sure. Your Honor, the only week I would not be available is the week of St. Patrick's Day. Other than that, I'm available.
Okay.
Your Honor, what is the subject matter jurisdiction of this court? I challenge the subject jurisdiction of this court.
Well, you have to file a written motion, Mr. Howard.
I was gonna say he's back to try to pull the substitute bullshit.
All right.
For the record, huh?
Yeah, yes, you've established on the record that you have no idea what the procedure is. but if that makes you happy, okay.
All right.
Who's the injured party in this matter, Your Honor?
Mr. Howard, what?
The injured party in this matter, Your Honor?
The what?
Who's the injured party in this matter?
My brain cells.
Is a victim in this matter?
Yes.
Okay, that would be the person probably that you're supposed to pay child support to.
I love it. It's a favorite soft-sit trope. Who's the injured party? It's not necessary, so it's all dopey. But in this particular case, it's very clear. There's a very direct line, and he hasn't paid some child support, and there's an assault apparently. I don't know, even get the complete unnecessary charges, but he actually tries this routine in something where you can answer the question without thinking, and the judge just enjoys saying, well, I mean, if you're asking this, I don't really need to answer, but here's a good answer for you nonetheless. Oh, it's too good.
All right, so I'm looking, how about April 28th at 9 a.m.? Are you available that day, Ms. Brenner?
Yes, Your Honor.
So I'm going to set this for trial on April 28th of 2022 at 9 a.m. And Mr. Howard, that is in person, scheduled for 1 day. I am going to set a motion deadline for April 13. Wait. Yeah, you're good. No. Yeah, you're good. Okay. Are you available April 13th, Ms. Brenner?
Yes, Your Honor.
All right. So this is a motion deadline. So, Mr. Howard, all motions must be filed and heard by April 22nd, which means you have to file it in accordance with court rules, with notice to the prosecutor's office, as well as the court. I'm going to require, Mr. Howard, that your jury instructions are also due by April 13th of 2022, as well as any voir dire questions. So,
right there is a good example. I say it all the time, but here's yet another example. It's very simple. He doesn't understand any of it. It's not helping him. But she's sitting there spoon-feeding all this to him and explaining what needs to be done. It's not out of line. That's what you have to do with pro ses. But while the stated rules, they get treated the same as attorneys, they don't. If I'm sitting there defending him, or Salvatore Motaro, she's saying, there's a motion deadline for this date. I presume you know everything that entails, and good luck.
Mr. Howard, this court does voir dire, but I do accept suggestions for questions to be asked, and understand they must be in accordance with court rules. And if they are not submitted by that day, then you will not have the right to add any. Do you understand that?
No, he doesn't, Your Honor.
Yes.
I have it all written down. Yes, I have it all. I mean, I don't want to accept it, really, but okay.
All right, so I'm going to mail out the scheduling order, Mr. Howard. Okay, so we will make sure the scheduling order is mailed to you at that address. All right, so I have a motion deadline and motion in limine deadline filed and heard by April 13th of 2022. And all suggested or proposed jury instructions in the appropriate format must be filed along with voir dire questions by April 13th of 2022. Mr. Howard, I believe you can access jury instructions online. You'll have to find them for the state of Michigan. And we're set for trial on April 28th of 2022 at 9 a.m. And understand, everybody needs to understand, I do take people in custody if there's a conviction. All right, so heading sentencing. So, Mr. Howard, we will see you back for any motions. If you file, I mean, I understand if you file a motion, you have to prepare a notice of hearing and a proof of service, and it must be served on Ms. Brenner as well as the court. Do you understand that?
No, Your Honor.
Yes.
All right, and you, once again, I'm going to ask, you do not wish to have standby counsel for trial?
No, I'm a man. Stand with the
No,
skin.
I'm an idiot, Your Honor.
I don't know what you said, but okay. Thank you. Thank you, Mr. Howard. Have a good day.
Thank you, Your Honor.
Thank you.
Oh, well,
Oh my God, Mike. Stop giving me substance in court, please. But I will admit that was actually quite decent. Very quite decent. Alright. Well, while this fight's going one more time again, I will take a look. And I know I've tried for the last couple days, and we've failed to be able to pull it off. But let's see, just in case we're able to find a subset. Case. Oh, I'm sorry, a Hyper Judy case that is. Wait, Japan was hit by an earthquake? Really? I'm gonna play a news clip. This might have to get muted because it might get a copyright strike. Screw it.
Of a strong and powerful earthquake in Japan. We've received some pictures now, and I can give you a little bit more detail. A tsunami warning, indeed, has been now issued in Japan after this powerful earthquake, which measured 7.3. Now, the earthquake struck off the northeast coastline of Japan, but this has repercussions, and as you can see, many homes in Tokyo and other places have lost power. At least 2 million homes have lost power, some in the capital, Tokyo. As I say, the epicenter of this earthquake was off the coast, but a metre-high wave is expected to hit land, and people have been warned to move away from coastal areas because of fears of a tsunami. But I think these pictures give you a sense of the strength of that earthquake.
And by the light of the day, it looks like either a power plant or something exploded. Because you see a big explosion of light in the background on both of the camera shots the BBC is providing. And then a lot of darkness. I will keep an eye, and if we have more information when we go into the overnight, we will definitely do so. Till then, though, like, share, and subscribe. Get us to those goals of 50,000 views, 1,000 subscribers. To, of course, get those nice red packages sent this way. CoinBase and Ibotta are below as per normal. So go ahead and get your freebies there. And until next time, like, share, and subscribe. Be kind to one another. And we'll rock and roll as we march through them. And remember, next episode is Art Bell in the Overnight. We finished with the UFOs. What's next? You'll have to come back and see next time from day one. We'll see you in the overnight. Until then, have a great evening.